Thanks everyone for joining us today. Maybe just to give a bit of background to Africa Solved. We are a corporate legal and advisory firm. We lawyers by training, and we advise on, our focus is basically cross-border mergers and acquisitions on the continent. We advise from the beginning of a transaction, from term sheet stage, all the way until closing of a transaction. So today's session is focused on term sheets, quite obviously. So we're just going to discuss the key aspects of term sheets and what you should be thinking about in discussing term sheets and negotiating them. So it's useful just to put term sheets in the context of the larger transaction process and structure. So we won't talk about any of these in too much detail, but obviously when it starts out, we look at a deal origination, so that's when you would go out to identify potential investors into your business. You would then typically sign a non-disclosure agreement. Obviously, certain confidential information will be exchanged at that point. You want to keep that protected. Typically, you would then enter into a term sheet, and this is where our focus will be today. Thereafter, the process goes on to due diligence, then transaction structuring. Generally, you determine whether you would like a holding structure or how the investor's coming in. That'll come in there. Then there's the drafting of the substantive transaction documents based on what's been agreed in the term sheet. Then depending on if there's a cross-border aspect, we'll look at briefing local counsel to get advice on specific aspects. Then there's warranties, indemnities. This is where lawyers get really excited, and it's the more complex part of negotiations. Then there's disclosures against warranties, the signing of the substantive documents, and then we proceed to closing and satisfying conditions precedent. Now, I've just mentioned a whole lot of buzzwords which will hopefully become clearer as we go along, but obviously feel free to ask me any questions and stop me at any time should you have any specific questions. So we've tried to divide here and group general terms together, which are typically included in a term sheet. Some of them would be fairly obvious, others are a little bit more detailed, and we'll discuss later on in the presentation and go into further depth. And we'll cover certain of them just now on this slide. So a quite obvious one is the parties, right? So I think at the outset it's important to identify who your counterparty is going to be. You may be having negotiations up front with the parent company, whereas in reality the investment will come from a subsidiary of that parent company. So it's important to identify who in fact will be investing, will be providing that funding or becoming your equity investor. It's also good to identify upfront if there's any counterparty risk, right? You wouldn't want to be, as an example, contracting with a subsidiary where the holders or the shareholders are politically exposed persons, for example. So it's just good upfront to identify any counterparty risk and ensure that you've properly identified your counterparty. The next one is introduction. So this is the softer aspects of the transaction of the term sheet. You want to get in there what you're aiming to get out of this transaction. So if it's a strategic investor that you're looking to introduce into your business, you want to lay out what you're expecting that strategic investor to bring to the party. So if it's a network of connections that you're looking for that partner to bring, it's good to be open and honest about that upfront to manage expectations from the start. The next one is the structure of investments, and this is where we'll delve into further detail later on. But I suppose the broad question here is to determine whether you're looking to raise debt funding or equity funding. The next one is conditions. Conditions, and I'm sure you've heard conditions precedent, these get thrown around. It's basically conditions that have to be satisfied before the deal can complete, so before funds can flow, right? And these are often identified in the term sheet and later fleshed out in the substantive transaction documents. The next one is transaction process and documents. So at a term sheet stage, you will identify the substantive documents to be entered into. and then include also the key terms of those documents. What we encourage is to have difficult discussions up front, right? You want to get the contentious points out there and come to agreements as soon as possible to determine whether in fact your counterparty is keen on the deal and wanting to proceed. I think a lot of the time people get a bit stressed about having these discussions and upsetting the counterparty too soon in the process, but you rather have the discussions up front so that you're clear on where you stand. The next one is exclusivity, and we'll discuss this again later. So investors are obviously always keen to bed down exclusivity. They don't want you going shopping around the terms with a number of investors. So it's a question, right, whether you're going to give the investor exclusivity or not, and we'll have the discussion a bit later.
You talk about during the process?
At term sheet stage, yes. So whether you're wanting to have negotiations with the counterparty exclusively. And it's a question about whether you want to give it. It depends.
Do they normally ask for it?
Typically, yes. And then it's a question about if you're going to give exclusivity, then you can have a discussion around a break fee, right? A break fee means if the transaction does not proceed, you will be entitled to a certain amount of money as a break fee, right? So that's kind of the tit for tat give and take, basically. But it depends, right? Exclusivity is often a difficult discussion. And I think if you're looking for funding, it's difficult to give one investor that upfront too early on in the process. So you just need to be careful, and it's a judgment call at the end of the day. Okay, then the status of a term sheet. So is a term sheet legally binding or not? We'll get to that answer later on. And then boilerplates, right? These are the boring terms that I'm sure have seen in various forms. So it's confidentiality, governing law, just the terms that should be included but don't really take too much of a discussion. Okay. So structure of the investments. Can everyone see this? Is it a bit small? We're good. Okay. So as I said earlier, up front it's important to determine what type of funding you're looking for, right? So you need to think about what is the purpose for raising the funding. Okay. Are you looking to raise capital through an investor? Are you looking to attract an institutional investor of record, or are you looking for a strategic investor? And once you've answered these questions in your mind, it's often easier to determine who to target. So then it's the question of debt and equity, right? So a question of whether you're raising debt also depends on the maturity of your business. So a business which is more mature and has a balance sheet, it's often easier to raise debt funding. And debt funding in that event can be cheaper than raising equity funding. And you're obviously also not giving up a part of your pie. But whereas at startup level, it's often difficult to attract attract debt funding because there's not much to secure against. And then equity funding can obviously make sense in a number of instances, right? If you're looking for a strategic investor to back you up, they're going to want equity. They're invested in the business, so you're going to have to part with some of your pie. And we'll talk just further on about the form of equity funding. So if we're talking about debt funding, what form does this take? So these are, again, a few buzzwords. It can be bilateral loans, mezzanine finance, preference shares, convertible loans, convertible notes, which I'm sure in the fintech space you guys are familiar with. Basically, it depends on what you're looking for. If you're wanting an arm's length relationship with a funder, a term loan over a period of time, paying interest, you're looking at a bilateral loan. Whereas if you're looking for something a bit sexier, you're looking for a convertible loan, right? Convertible loan is upfront debt funding, and then on the happening of a certain event or reaching of certain milestones, it becomes convertible into equity. So that kind of straddles the debt and equity divide. Then if we're looking at equity funding, and I think people often get confused here, is you're looking for a subscription, right? as opposed to a share purchase. A share purchase is when you buying an existing shareholder out, or an existing shareholder is selling some of his shares. And ultimately, if an investor comes in and buys shares from that individual or that shareholder, the money goes to that shareholder. Whereas you're looking to raise funding at the company level, right? So you have to do so by way of a fresh issuance of shares. So an investor will come in, subscribe for fresh shares, and the company receives that money. So definitely in the context that we're discussing, you're looking to raise equity funding by way of a subscription for shares. I think I've covered that. And we can also, in the context of equity funding, it can also be a component in the form of equity and a component in the form of shareholder loans. And that will obviously get preferential payment rights as opposed to dividends, for example. Any questions? Cool. So the next one, and we touched on conditions earlier. So as I said, transactions of this nature are often subject to conditions precedent, right? At term sheet stage, the certain obvious ones can be identified up front. So for example, the investor will likely want to do a due diligence of your company. So that'll be a condition to the transaction. Often, and we strongly advise so approvals, right? Approvals, often there's regulatory approvals, which are out of the control of the parties. So for example, if you're doing a cross-border transaction, we have exchange controls in South Africa, and money will need to flow offshore, and you'll need exchange control approval for that. Now that is out of the party's control. Whereas internal approvals, and we would strongly resist this, is because you don't want conditions that are in the control of one party, and in this case it would be the investor. So you'll often, if you're dealing with private equity funds, for example, they'll insist on having a CP that this transaction is subject to internal approvals. Basically, this is a walkaway right for them, right? You don't want to be questioning their intention up front, but you must just have it in your mind that if it's subject to internal approvals, they can come back at the last minute and say, look, our board said we can't proceed. You've gone far down the process. So up front, you want to ensure that they've obtained whatever approvals they need to get into to enter into the term sheets and proceed along that road.
But how do you do that? Because sometimes you're not actually sure what the nature of the transaction is going to look like.
No,
and people might get uncomfortable,
yes,
with what you're saying or what you're requiring, and then it does get bulleted further down the line.
Yes. Look, it's difficult, right? It's a question of chicken and egg. You just need to, I think it's more about making your counterparty aware that you're thinking about this stuff, right? So if you're asking the right questions, so if you say, I appreciate this kind of stuff needs to go to your IC, has our transaction been presented at IC at an initial level, You try and push these questions to make them, to encourage them to think about what they need to do to get their house in order to proceed. So I'm not saying often, right? Often transactions land up being subject to internal approval. But from your perspective, and if I was advising you, we'd try and resist it as much as possible. And obviously, the transaction structure changes. I mean, these things are like live animals, and everything's changing all the time, right? But you need to try and ensure that there's in principle approval to proceed to have discussions with you. That, the IC is aware of your company. It sounds good, right?
You're acting quite strong when you go down that road, though.
Sorry?
I'm saying you're on your front foot when you're doing that.
Yes.
Because you're basically saying, like, if you agree to stuff with me in this term sheet, it's going to be binding.
Yes. Okay. Then, obviously, as a condition to the term sheets, it will be entering into substantive transaction documents, and we'll touch on the terms of those later on. What else have I included here? Oh, and often further conditions are identified as part of the due diligence, right? So it's very normal where a company undertakes a due diligence of you, and as part of the due diligence, they'll identify issues that they are uncomfortable with and they would like you to remedy before they make an investment, right? So for example, if there's an existing tax liability, they want you to settle that liability prior to their investment. And that often comes out in the due diligence. The next one is the transaction document. So for the purposes of this discussion, we've assumed that you're raising equity funding, and that you're entering, and the main transaction documents in this instance would be a subscription agreement and a shareholders agreement. Now, a subscription agreement is the document that deals with the here and the now, so facilitates your investment, sets out the conditions, sets out the warranties. The shareholders agreement is the document which will govern your relationship going forward. So a subscription agreement, right? So as I said, it contains the conditions, it contains the terms on which the investment will be made. So the subscription agreement will set out your subscription consideration, your warranties, your representations, your undertakings, and basically the terms that will enable the investments. Now, warranties, as I said, is what gets us excited, and this is quite a difficult discussion, right? But at term sheet stage, what's important is that you identify the categories of warranties that you'd be willing to give to the investor. So it's obviously premature to include a comprehensive list of warranties at term sheet stage. What does need to be done is just to identify the categories, as I said. So if the investor is uncomfortable generally about tax, right? People get uncomfortable about tax liabilities. They will request warranties relating to tax, right? The usual ones are tax, accounts, employees, if you employ a number of people, intellectual property in your context. So as long as the categories are defined in the term sheet at the time of the negotiating the transaction documents, it's a lot less of a discussion, right? You'll say, but in the term sheet stage, you had raised this as an issue. And I appreciate that it is premature, right? And you do have discussions in type of abstract at term sheet level, but there are certain things that the investor will require, and if they need to be upfront about that, right? And if it's recorded in the term sheet, then you're in a lot better position at the time of entering into the substantive transaction documents. I think another thing to think about in the context of warranties is, what are warranties, right? Warranties are about an allocation of risk. An investor is coming into a company that you've been running, okay? Ultimately, if something goes wrong for the historic, about the historic liabilities, ultimately you need to stand good for those, right? So the investor is not going to assume the risk in respect of historic performances of the business. And warranties are a mechanism for the investor to protect his value. If he's coming in, putting in money, he wants to be comfortable that actually the business is not indebted to the hilt and all his money is going to be used to settle historic debt. So it's kind of like a snapshot of the business, a protection around that snapshot at the time of the investor coming in. Now, depending on the nature of your investor and the type of the investor, they can consider further protections in respect of warranties. So I'm not sure if you've heard about like escrow arrangements. So if there's an identified risk at the time, an investor could look at putting a certain amount of his money, which he's putting into escrow, as protection against those warranties. Then a shareholders agreement. Now, this is more the feel-good stuff, right? So you have to make sure that you include here how the investor is going to get protected going forward. So what we call minority protections. And this is probably the meat of what goes into the shareholders agreements, and there's obviously clauses around board composition, how many times board meetings should occur, when shareholder meetings should occur. And then an important one is funding mechanisms, right? So when a company is at an early stage, it will likely require funding at a future date, over and above what's being provided by the investor. So this should be regulated, right? So we typically include a funding waterfall. At the first instance, you try go and raise third-party funding. Should third-party funding not be available, then obviously the shareholders may need to step in, and will it be proportionate, disproportionate, and there'll be basically a mechanism around that. Then reserved matters, I'm sure you've heard this word getting thrown around. It's basically those matters which require shareholder approval over a specific threshold, usually at 75%. So this is quite a lot of detail around the shareholders agreement, and obviously in the term sheet what needs to be included is the key commercial terms around this. So quite often we attach a reserved matter list to a term sheet so that we can be clear on what the investor requires up front. I think we can move on.
Can I ask a quick question on the shareholders agreement?
Sure.
So obviously, I mean, let's assume the deal's done, you've raised your equity through a subscription, and simple terms of the shareholders agreement are, do a board meeting once a quarter or whatever it may be.
Yeah.
I mean, in our instance, our shareholders are quite relaxed because we engage with them on an informal basis very regularly. So
Yeah.
they are kept up to speed with how the business is doing on a more informal basis. And as
Yeah.
a result of that, I often say, we don't really need to have a formal board meeting, but
Yeah.
in the shareholders agreement it says we'll have a board meeting once a quarter.
Yes.
I mean, how important is it to formally have that meeting, because
Yeah.
it is in the shareholders agreement
Yeah.
versus the fact that in reality are
Yeah.
kind of up to speed on a regular basis, and they don't really want to come for a formal meeting
Yeah.
because they know what's going on.
No, obviously, and it's obviously good to keep your shareholders regularly updated. So the importance of board meetings, there's a number of factors around it, right? So in as much as they're aware of what's going on, it isn't really documented in a separate board pack or in minutes, right? So at the time, so if anything goes wrong, right, and obviously directors have fiduciary duties, you want to always be sure that those directors have been kept fully appraised. There's records of meetings happening. There's records of board packs. There's record of decisions. So it's more about a process thing, right? So obviously you can keep a board meeting to an hour long if they're familiar with anything, but I would really strongly advise that everything is clearly documented, because down the line you don't want to be in a position where you've taken a decision and it turned out to be a bad decision. The shareholders are then asking, but who'd made this decision? And you'll say, but we had that discussion, remember? It just becomes a difficult place to be in. So you don't have to have it every quarter, right? If it turns out that every 6 months it's fine, you can say the board has taken a decision that every quarter board meeting is not required, but you do have to formalize the process just to cover your bases. Does that answer your questions?
Sorry, so if on the example of having more informal meetings, but you're still keeping records and minutes and so on from those meetings, would that suffice, or should it really be an official board meeting?
So an official board meeting would mean, right, that the chairman of the board has to sign off on the minutes. It's a true reflection of what was discussed at that meeting. It's just good governance, right? So obviously it's good if you take notes and informally record things, right? But there can then always be a discussion about that. I actually didn't mean that when I said that.
They could dispute what my minutes say.
Exactly, yeah. So it can be a pain, right? I hear that, and for a smaller company, it does become quite a laborious task, especially when you're spending your time more efficiently. But I would advise that you do formalize the process just to be clear that you've got the mandates and. Okay, and then how much you want to give up, right? So there's percentages that mean certain things in the context of shareholding, right? So obviously, a majority shareholder is a 51% shareholder in shareholding, and that just means that a 51% shareholder controls the company, because any decision, ordinary resolution requires a 51% vote. Then we talk about significant minorities. Or I see my thing messed up a bit there. So significant minority is 25%, right? 25%, because usually special resolutions require a 75% majority. So if you have a minority shareholder that's holding 25%, they can potentially block any decision. And then you've got the 10%, the 5%, and anything below 10% we would consider to be an insignificant minority. So what do these percentages mean, and what should significant minorities be afforded from a minority protection perspective? So what are minority protections, right? An investor is interested in being able to control certain key decisions of a company, right? And how does an investor do that? it's equipped with certain rights. And these are called minority protections. And these come in various forms. We spoke briefly about reserved matters.
So just before you move on, just while we're on the question of board meetings as a shareholders meeting.
Yes.
The resolutions, could you just speak to them in relation to where those meetings happen? Is it at shareholder level or is it at board level?
Yes. So from a governance perspective, right, the board is mandated to run the company. So the board has general powers relating to the management of the company. So day-to-day decisions can be taken, most of the decisions can be taken at a board level. Certain reserved matters, those are shareholder matters, right? Those require shareholder approval, right? And there's also ordinary shareholders. So 51% is an ordinary resolution, and reserved matters are a 75% resolution. So maybe I must answer this more clearly. At board level, there's also resolutions that can be taken. So at a board meeting, certain matters can be tabled for decision, and if a majority of the board agree on the matter, then that's taken at board level and it can be implemented. Then certain matters, as I said, reserved matters are identified as shareholder matters. These have to be referred to shareholders for a decision. Now, what's important to consider in this context is fiduciary duties. So directors have fiduciary duties. They have to act in the best interest of the company, taking all factors into account, right? Whereas a shareholder doesn't have fiduciary duties. So a shareholder needs to think less about the interests of the company than a board does. So in trying to push things to a shareholder level, just bear in mind that they don't have a fiduciary duty. So often shareholders act in that particular shareholder's best interest, not thinking about the interests of the company. Does that kind of answer your question?
So how do you define the day-to-day business of the company to then be able to know if it's the right decision at the board level and can be contested or not by the shareholders? So,
look, it's difficult, right? And I'm not familiar with your business, right? So, but the day-to-day operations are things that the decision of which won't make a significant impact on the strategy of the business, on the value of the business. So everyday decisions that you need to make as and when not to hamstring the business, right? Whereas more substantial decisions that should be taken at a board level are, for example, employing someone where you're paying them R1 million a year, as an example, right? You wanna discuss that with your board members and make sure that everyone's on board in hiring this person. So it's kind of a judgment question. But shareholder matters that require special resolution should be recorded in your shareholders agreement, right? So it will be clear that raising indebtedness more than 5 million rand, you have to refer that decision to your shareholders to consider and make a decision on.
And that has to be on the MOI, right?
Yes, in South Africa, yes. Okay. So the decisions are minority protection, then obviously a board representation. So depending on the size of the shareholder, they can be entitled to appoint a director to the board. So we often say any shareholder holding 20% or more is entitled to have a board representative. And then there's share transfer rights, right? This is where the investors protect their value. Share transfer rights basically govern how shares can be traded and transferred in the company. Now you would have heard preemptive rights. This means that before anyone in the business can sell their shares to an outsider, the other shareholders have a preemptive right. So they are entitled to buy the shares before a third-party shareholder comes in. Then I'm sure you've heard tag-along rights, deemed offer provisions, lock-ins. These are all rights that are afforded to investors to protect their position. I'm not going to go into too much detail here. Safe to say that if an investor requires a specific share transfer rights up front, they often ask for tag-along rights, which means that if someone comes in to buy the business and the majority shareholder is being bought out, they can tag with them. I would advise that these be set out in the term sheet. So under the shareholders agreement, you say the investor is looking to secure share transfer rights in the form of preemptive rights and tag-along rights, as an example. The question of how much you should be willing to give and when. Again, that depends on the type of investor coming in. And the percentage shareholding they hold. So, for example, a private equity fund that is taking up a 20% shareholding, they don't really want to get involved in the operational business, but they want to secure their value, and they're looking to exit at a point. And so they'll be interested in securing certain share transfer rights to ensure that after their fund is closed, they are able to dispose of their shareholding and realize value. So all I'm saying is, if you're getting a PE investor in, they'll be concerned upfront about how they're going to exit this business, right? And in that way, they'll be wanting to secure certain share transfer rights. Okay, the question of exclusivity. We touched on this earlier, and in our experience, investors are looking to, if they're serious, they're looking to be exclusive. And from your perspective, do you really want to give exclusivity at such an early stage? It depends, right? If you are set on this investor, you've identified them as the person you wanna partner up with, then you want to secure exclusivity. You want to make sure that they're not looking for another investment in the fintech space, and they're having multiple discussions, right? But you also, and then on the flip side is, if you're not 100% sure if this is your investor, you don't want to be tied to an exclusivity. So it's really a question of what you're looking for and who the particular investor is. Now, as I said earlier, if you are going to give exclusivity, you can then have a discussion around a break fee. You can say, look, you want me to not have any further discussions with anyone else. We need to talk about a break fee. I'm going to be investing resources. I'm going to invest in time. I'm going to facilitate your due diligence. You really need to come to the party. And if you're not going to, then we need to talk about a break fee. And a break fee is often a percentage of what the investment value will be. So if they're investing $1 million, you can say, I want a 5% break fee of $1 million. Then the question of legally binding or not, right? So in terms of law, a term sheet, unless specifically stated, is not legally binding. So in terms of law, we say an agreement to agree is not legally binding because the terms aren't sufficiently clear to bind someone legally, right? But what often happens in a term sheet is certain specific clauses are in fact said to be legally binding. So for example, confidentiality, that's an obvious one. You've now told this investor your life story, where you want to end up in 10 years' time, and this is important information to your business, right? You want to make sure that investor is in fact legally bound to that confidentiality clause. And is a term sheet always a good idea? And the answer is yes. You always want to make sure that you've set your expectations, that you understand where the investor is coming from, that if this is not the right investor, you've actually put a line in the sand and stopped wasting your time, right? And you can often tell this at term sheet stage. Yeah, that's it from me. Any more questions?
The break fee be paid by either party, depending on who broke the agreement, or was it only paid to the...
So it can be a reciprocal break fee, right? So that's why you're walking along a long line, right? So it depends on the sophistication of your investor, right? So upfront, you can say, look, this is an exclusive, I'm raising funding. In your mind, you want to use this term sheet to shop around. You don't want to commit to exclusivity. The investor may say, look, not willing to proceed unless you've committed to exclusivity. Then you counter that by saying, okay, cool, I can be exclusive if you were going to pay a break fee. They could be intelligent and then say, okay, then it needs to be reciprocal, right? And then at that point, you just need to be certain that, in fact, you are quite committed to this investor. It's difficult, right? Cool. Thanks, everyone. I don't think I introduced myself. My name's Eleni. That's Gabriel, my colleague, and Kirsten, my colleague. Cool.
How do you get yourself up to speed on all of this if you're going to engage? Because there's a lot of stuff in here that I don't really understand.
Yeah, no.
And if you're going to engage, it's quite difficult to be in the middle of a transaction being told, like, this is what they're saying, this is what it means.
Yes.
You kind of need to know these things up front so that you decide on your angle of engagement.
Yeah. No, I agree. So it's about putting in the time before, right? So I'm happy to send this this presentation to you. There's a lot of things that you need to do up front and be quite certain about where you have wriggle room and where you don't, right? And obviously in your position, you're looking for something from someone, right? So you are not necessarily in the strongest bargaining position, but there are certain things that you have to be clear on what you're not willing to move around on. And if you've got that clear in your mind, then you're obviously on a better base. As far as understanding what you should be thinking about, I think it's just a case of researching. It comes with experience.
Maybe spend time with whoever your counsel is.
Yes, no,
prior to really engaging.
Yeah.
To say, right, let me understand, show me an example of a transaction.
Yeah.
Or what does this really mean?
Yeah. And look, a lot of the time in negotiations, if you've got counsel there, a lot of the time counsel often says, I need to take instructions from my client. Can we just have a few minutes to discuss this, right? And then you can think about the different angles. So it's not necessary to make a decision in that moment on what you should be agreeing, right? It's very normal to step aside and just take some time to think about what it means.
Sorry. Do you provide assistance?
Definitely.
How does that work? How much does it cost?
So I can give you my business card. We can have a discussion, right? Depending on what your requirements, how we structure it. So we don't charge hours, right? We quite different in that way. We work on success fees, but it's a discussion.
Okay.
So happy for you to mail me.
Very interesting. To incentivize to close.
Exactly. What interests are aligned.
Performance fee.
So I understood that in terms of the various debt options that you mentioned, I understood
Yes.
the convertible loan.
Yeah.
What is that convertible note?
So this is a buzzword that's come up in the fintech space, right? And I think so it's more where a company has a number of fundraisers, right? So I think it's like seed funding, expansion funding, then like pre-IPO. It's all these buzzwords in Silicon Valley, right? And depending on the stage on which the investor comes in, they can be given preferential rights to profits, right? I think it's basically similar to a convertible loan, but I think it's just in the form of a note as opposed to a loan.
Because essentially they'll give the business money which can be converted into equity at a later stage.
Exactly, yeah. And the conversion to equity can be on any triggers, right? In certain instances, it's linked to performance. You may at the outset not be sure if you want an equity investor, but if you don't reach specific milestones, that investor wants to cut their losses as a funder and step into the business and be able to, act on decisions. And I think what's important in the convertible loan context is you do need to agree your shareholders' agreement up front, right? Because at the time that they do convert, you want to be sure that the rights that attach to that converted equity is set up front. Cool. Okay, thanks everyone. I hope that was useful.